I'd like to call the meeting of January the 8th to order, please. Roll call.
Baker.
Here.
Carlson.
Here.
Russo.
Here.
Swigert.
Here.
Okay, before we go to the first item on the agenda, we have to read the following statement. Board of Adjustment is a quasi-judicial body created by the City of Iowa City according to state statutes. The board's purpose is to decide on applications for variances from the zoning ordinance, appeals of decisions of city officials, and applications for special exceptions requested under the zoning ordinance. Board of Adjustment is an independent volunteer board made up of Iowa City residents and is not part of the city administration. We are assisted in our work by the city attorney's office and by planning staff. Prior to this meeting, board members received the material submitted by the applicants, the staff reports reviewing the application, and any correspondence submitted by members of the public. Board members have not discussed the application or its merits with each other, staff, the applicant, or any other member of the public in advance of this meeting. All consideration and discussion by the board takes place in open meeting here tonight, where we will also have an opportunity to hear from the public. The board bases its decisions on facts and evidence allowed by state code presented in open meeting. Concise and truthful testimony helps us a great deal in our decision-making. We ask that if you wish to speak, that you come to the podium, print your name and address on the sign-in sheet, and speak clearly into the microphone so your testimony can be heard by all present and by our minute taker, as all testimony becomes part of the public record. We ask that the proceedings be orderly and that when you are testifying, you address your remarks to the board. If this hearing becomes lengthy, we may ask that testimony be focused on new facts or on information not already presented. The order of proceedings for the appeal application will be an introduction by the Secretary of the Board setting forth the administrative decision on appeal and appellant's grounds for the appeal, an opportunity for the appellant to speak, an opportunity for the staff to speak, an opportunity for proponents and opponents of the appeal to speak, an opportunity for rebuttal by proponents and then by opponents. The board will discuss the issues and evidence, state its findings, and vote on a motion. Motions are always made in the affirmative. I will introduce this item, but then I'm going to have to recuse myself. First up is application APL 24-0001, an application submitted by David Moore requesting to overturn a decision of the building official to issue a building permit for a single-family home at 319 North Van Buren Street, alleging that minimum lot size, setback, building bulk, and maximum lot coverage requirements of city code are not met, and his sewer line runs underneath the proposed structure, interfering with his easement rights. I'm going to recuse myself because this property and applicant were involved in a prior issue before this board, at which time I had a conflict based on prior conversations, and I recused myself. And to be entirely consistent with that, I'm going to have to recuse myself on this issue as well. And I'm going to turn it over to the vice chair at this time.
Thank you. At this time, I'll open public hearing, and we'll have an introduction by the Secretary to the Board regarding the administrative decision on appeal and the appellant's grounds for the appeal.
Good evening, Parker Walsh. And I do want to add that in cases of a recusal, the Board of Adjustment bylaws do allow staff to appoint an alternate, that being Ernie Cox graciously joining us tonight. We also have an independent consult tonight to represent the board, that being City of North Liberty Attorney Grant Leentz. And due to this being an appeal of the building official decision, I am only acting as the Board of Adjustment Secretary tonight. A little bit of background. The building official issued a building permit on November 2024 to allow the construction of a single-family home at 319 North Van Buren Street. And then the city did receive an appeal application before us tonight in December 2024. And as the chair mentioned, this is an application submitted by Mr. Moore requesting to overturn a decision of the building official to issue a building permit for a single-family home at 319 North Van Buren Street, alleging that minimum lot size, setback, building bulk, and maximum lot coverage requirements of the city code are not met, and that his sewer line runs underneath the proposed structure, interfering with his easement rights. With that, I turn it over to the board and resume my role as secretary.
Okay. So at this time, would the appellant or the appellant's representative please come to the podium, sign in, state your name, and state the grounds of your appeal.
Good evening. As you may recall, I have had the pleasure in the past of talking to some of you about this same property before.
Could you
It's-
please state your name? Thank you.
My name is Greg Gertis. I'm a lawyer in Iowa City. I represent Mr. Moore. I'm going to hand you some documents. I prefer to work off of these rather than slides because it gives you things to refer to.
Thank you.
Thank you.
Thank you.
Thank you.
Thanks, Greg. As mentioned by your secretary, the issues here can be summed up into 3 or 4 different problems. First problem that I'm going to talk about is the sewer line issue. And then we're going to talk about setback issues. And there's also a parking issue.
Excuse me, the sewer issue is not under the jurisdiction of our board.
Let me explain why I respectfully disagree.
If you can do that briefly.
On page 7 of what I just handed you, there's an excerpt from the city code. This is in Title 14, the zoning code. It's not in the building code. It tells you what it is you are to consider, what you can do, and what you cannot do. And it also says that if you have a conflict, if you've got 2 different code provisions that are in conflict, you choose the one that is most restrictive. In response to your specific question, underneath B, I've highlighted it in yellow near the top. This title, that's the zoning code, is not intended to interfere with, abrogate, or annul any easements, covenants, or other agreements between the parties. It is our view, and the evidence is going to clearly show, that this sewer line has been there for over 100 years. And underneath that code section that I just cited to you, you are powerless to take action which interferes with those rights. It is our contention that the building official has violated that section by depriving Mr. Moore of the benefits of his sewer easement and by interfering with those rights. Therefore, it is the building official's error in granting the permit which interferes with the construction, which is one of the grounds that we are appealing. The building official lacks the authority underneath the zoning code to do what was done. That is one of the reasons why we are appealing. It's just a matter of applying the code. If you go back to page 2 of what I just handed, it's a letter from the city with a photograph which shows our problem. Mr. Moore has lived at 425 Davenport Street for more than 40 years. You can see the purple line, which is Mr. Moore's sewer line. It goes down towards the southeast at a slight slant and then crosses 319 Van Buren Street. Previously, up until about 2017 or so, there was a very small cottage on the far easterly portion of 319. The sewer line went to the west of the structure, and the small cottage did not pose any threat to the existence or the use of that line. The structure that the building official erroneously approved, however, the foundation is in the ground. It sits directly on top of the sewer line. It is our contention that underneath the code section that I have cited to you, that certainly interferes with the existence of that sewer line. It may or may not have been broken in construction. It may or may not have been already damaged. It may well be damaged in the future, and we may not be able to fix it because this line has been covered up by this house. Now, it may well be a violation of the building code also, but your zoning code, the code that you have full jurisdiction to implement, also addresses it. And it simply was an error for the building official to ignore our rights and to interfere with the use of that sewer line. Second issue that we would like to bring to your attention, and again, I think the background here is important. This is the third time that this property has been before the Board of Adjustment. On two other occasions, and I've taken the liberty of attaching those decisions to what I've handed you, there were setback violations that the building official approved erroneously, and this board granted the appeal, overturned those decisions of the board. Primarily, I was involved in the last one. The last one involved a front setback violation. This one now, again, involves the front setback violation and other violations. And I will go through them one at a time. On page 6, we've got the front setback violation that we are concerned with. Page 6, there is a highlight of a portion of the building plan. The actual building plan is on page 25 of what I've handed you. And if you'll turn to that, you'll see highlighted in yellow what has been enlarged and incorporated into what I've just handed you. Now, on page 7, I quote section 14, 2B4, parens 4. Now, I agree that there is because of setback averaging, a 9-foot, 8-inch front setback requirement. The issue then becomes what can be put into that setback that is legal. There are only limited types of things that can intrude into a setback. And when you look at 14, 2B4, you see where ramps can intrude into a setback, but only by 8 feet. That's the code. When you look at the construction plans and the highlighted portion on page 6, you can see that their proposed ramp intrudes by 9 feet, 6 inches. Now, a foot, foot and a half in this case may not seem like much, but this is a house that is only 10 feet from the lot line. It's a fairly large house, about 2,100 square feet is proposed, and it's right up to the sidewalk. You may remember that last time I was here, we were talking about a proposed front step that intruded too far into the front setback in violation of the code. And they have replaced that step, that illegal step, with a ramp. Unfortunately, the ramp also intrudes onto setback. The next violation is also shown on page 6, and that's the side setback obligations and requirements for ramps. They are required, in this case, the ramp, as you can see, goes all the way to the lot line. It intrudes the entire width of the side setback. However, when you again look at 14(2)(b)(4), parens 4, it must be set back, and this is quoted on page 7, it must be set back 3 feet. Therefore, the ramp violates side setback requirements in addition to front setback requirements. Then we're talking about a side setback problem on the north side of the house. I am on page 8, underneath number 2. Second, as shown on the site plan, window wells intrude into the north setback by 3 feet. That's shown on the site plan, which is on page 5 of your document. They're highlighted in yellow on the north side of the property. Windows are not permitted to intrude into side setbacks. Again, the list of things which can protrude into side setbacks are on page 7 of what I've handed out in section 14(2)(b)(4), parens 4. There are a number of things that are permitted. Windows are not permitted, and I also note that bay windows are specifically prohibited from being in the side setback. This is a window well. I don't know if it falls underneath the definition of a window, of a bay window or not, but it is essentially the same scenario. It certainly is not allowed in the side setback. Again, those things which are allowed are contained in the ordinance that I've quoted to you. The last issue is combination of parking and setback. When you look at the site plan, again, which is on page 5, you'll see a parking stall highlighted in yellow, which is towards the west end and on the south side of the property. Underneath the code, which is cited on page 8 of what I've just handed you, off-street parking is subject to setback requirements. That means that your off-street parking spot has to comply with the minimum 5-foot side setback. As you look at the site plan, you will see that there is no setback there. It's parked and built right directly on top of the sideline with no setback provisions at all. The issue of the sewer line is a very, very big deal. You know, what are we going to do if our sewer line is disconnected, is lost, is broken? Obviously, could be a tremendous expense to get it fixed if we have to fix it. I am also concerned about some inconsistencies that the building official has exhibited in this matter. Following me, I'm going to ask Mr. Frank Wagner, who's a local contractor, to tell you what his experience with this issue has been. And I think you will find that enlightening. And lastly, I have a point that I would like to make. I don't know if it affects this appeal so much as it affects how you conduct the board going forward, and that's with the timing of this whole matter. We filed our appeal. Let me get the exact dates. We filed the appeal on December 10th, and the city's stop work order wasn't issued until 10 days later. And then after the stop work order was issued, substantial work continued on the property, including the installation of the entire first floor, complete with joists and tongue and groove plywood flooring, subflooring, and framing in the basement. The stop work order is there for a reason. It's to prevent illegal construction from going forward. It's to minimize the loss to the public and to the builder. But I certainly do not want there to be an argument that, well, we've completed the foundation and we've completed all this and we've all done all of these things. Let's just let it go, okay? That's why it's a mistake to wait so long in issuing stop work orders, because if that had been promptly issued on the date of the appeal, things would be a whole lot different and would look a whole lot different than they do now. All right, those are my summary. More detail is enclosed in what I have given you. There's also materials that I've supplied that are included in the packet that you got. Are there any questions that I can answer?
Does anybody have any questions at this time?
There's a lot of new material.
Yeah, there is a lot of new material. We haven't had an opportunity to look
No, I
at.
understand, and maybe what makes sense is to defer your decision until you've had a chance to come up to speed on things, because the other side has has room to talk and an opportunity to talk too. So there's lots to consider.
I haven't had a chance, we got our package Friday. And this is, a serious and complicated and multifaceted issue. I haven't had a chance to digest much of that, let alone this new material.
No, I understand.
Now, when I find out that it was accelerated for some reason, I personally am inclined to ask for more time.
Yeah, let me, I have no objection to that because I understand that you folks are, coming out, kind of from the cold with this. There is an issue about what the timing should have been for this appeal. And if you look at the scheduling deadline that you folks have issued, if that deadline had been complied with, we would be doing this at next month's meeting. So this process was accelerated for reasons I don't know and protested.
That process is not under the control of the board, except to agree whether we can meet or not.
Again, I would respectfully disagree with that because this is your scheduling order. It's your deadline. If you look at page 36 of what I handed you, it shows the schedule for the Board of Adjustment. We filed our appeal on December 10th of 2024. And by the Board of Adjustment deadline set out there, that was to be heard on the February 12th meeting. It was accelerated, and that's part of the reason why you've not had a chance to review things. And it's also part of the reasons why we've been rushed in trying to get this done. It's hard for everybody. So, any more questions?
I do have a question of why this came up now, because we had been informed that there would be no meeting in January. And then we got a notice from the staff asking if we would be available for this meeting,
Madam Chair?
which confused me.
Madam Chair?
Yes.
So I'm Grant Lynn, speaking for the first
Yes.
time in the meeting here, North Liberty City Attorney here, but I'm here advising the board tonight. I don't want to step too heavily on the proceedings here, but this issue was raised in advance of the board's meeting with respect to the timing and whether the calendar's date. My interpretation of this body's rules for its calendaring was that today is the proper date for this hearing, based on the timing of the application, the deadlines, and the board's own rules for when the calendar is set. My interpretation of those rules, which I informed Mr. Gertis and Mr. Goers, is that today is the proper hearing, and I advise you of the same. Okay? I don't know if the board has particular rules about the voluminous nature of the things, but I other than to say I would advise you all to take the full record into account and take time to issue the decision that you think is appropriate. Now, I don't want to step on your presentation. I know you had more, but I have to walk a careful line as far as giving advice here. So I want to make sure that you are considering all the evidence. But today's the day. You certainly have the right to continue these proceedings later on if you want to, but you should plan on having a full meeting tonight. And if you run out of time, you can schedule further deliberations at a future date.
Can you explain that? What Mr. Gertis has said is that the deadline for submittal was December 6th for the meeting of January
Yes.
His
and-
submittal occurred 4 days later?
December 10th.
Okay. What rule do we have that allows that?
The procedural rules, let's see.
I mean, is it discretionary on the part of staff? How does this work? I mean,
No, the city ordinance says the board adopts the rules as far as when hearings are. The board's rules say you hear regular meetings on these days, and if you have submitted by a certain day of the month, then your hearing is on the next scheduled day. My reading of that and my advice to you is that today is the correct day for that. I don't have it right in front of me. I'd have to pull it up, but that was the advice I gave to both the parties, and that's the advice I'm giving you now.
I don't understand that. Are you able to speak to, I think there's a couple of concerns I have is in our packet to prepare for this meeting, I don't think there was any discussion of the potential violations around the ramp or the side parking stall.
I think that if that was not a matter that was properly raised in the appeal, that the board should not probably consider it. So if you have new information, but I think you should err on the side of considering evidence, right? Of considering evidence. Is my mic on? Okay, I want to make sure you can hear me. So I'm not going to say that you should exclude evidence just because it might not be timely. With your respect to your schedule, I would encourage the board to give till it hurts and spend as much time as you can to consider the elements in front of you.
I would respectfully like to respond to that. I don't know how I can make it any more clearer that setback has always been an issue in this case. Obviously, the city knows about it because they're the ones who prepared that slide right there, and it most clearly states setback. We're starting to get into the same problem that we've had in the last two appeals. That is that the city, in my humble view, is somewhat obsessed with having too big of a house built on this very small lot. We agree.
Mr. Gertis, that's not the question before the board tonight. The question is whether the building official erred in issuing a building permit, which is a ministerial act, right?
Thank you. I would like an opportunity to
Sure.
continue to follow up, if I could, sir. Setback is specifically mentioned. In the last two times, we've had similar violations caused by the city's much too fast planning to move forward to get too big of a house built on this very small lot. Any more questions that I can answer? Thank you for your consideration. Mr. Wagner,
Oh, hang on.
you could speak, please.
So at this point, if we're inclined to defer, do we continue to hear from the public or from representatives or anybody?
Madam Chair, I mean, we're all dressed up. I would suggest that we,
Go ahead.
the order is a statement by proponents of the application and then opponents of the application. My inclination would be to recommend that you continue with the hearing
Okay.
and until at such time as if we need to break for recess, the board has the ability to do that. I mean, absent an objection from or a consent from the parties.
Hello, my name is Frank Wagner. I'm a local contractor, residential contractor in Iowa City, and I just was asked to speak on an experience I had about 10 years ago on a property where it's a duplex at 109, 110 Summit Street. I guess that would be South Summit Street, where it tees into Washington Street. The duplex sits on a a hill on the south side of the lot, and the customers I had, the clients, who wished to build a 2-car garage to the north of it, of the structure. And when we issued this building, applied for the building permit, and it supplied a site plan, we discovered that our sewer line went right through where the garage was going to be placed. Now, I can't say with certainty whether the building plumbing inspector at the time, Bernie Oswald, said it was not to code to do so, but he advised strongly against it, placing the garage over the top of the 100-year-old sewer line, and advised that it be moved, that it didn't go underneath the garage, but circumvented the garage and then went under the driveway, which is permissible, and then tie into the sewer line. The difference here also would be, we then did that, my clients, we paid for that work to be finished, to be done. The issue here before us, I think, is not so much that it's, the sewer line is going under a structure which might not be to code and is definitely unadvisable, but that it should be moved and who pays for it. And it should not be the homeowner, because it's not his property. And it is the homeowner's responsibility to maintain sewer lines as long as it's on the homeowner's property. But the moment it goes through there, it becomes the issue of and the expense of that person. So, have any questions? I'd be happy to answer those.
Frank, just a inquiry. I believe the homeowner owns the sewer and the water line all the way out to the main.
Yes,
In
correct.
this town.
Yes.
Right? So how does that not remain his responsibility?
I think and this would be a question, I think, whether there's an easement going across another property. I think as long as it would be,
With or without an easement, it's still his
Yeah.
responsibility, correct?
I couldn't answer that question.
Okay.
But good question. Yeah.
You sure you want to continue?
Okay, at this time, let's have,
David was standing.
oh, David, did you wish to speak?
I do, thank you. My name is Dave Moore, and should I sign this? Is that what's going on?
Correct. Yes.
Okay. Pen just broke on me. Sorry. My name's Dave Moore, and I live at 425 Davenport Street. And at this time, I think I just want to say that this timing issue, the rules are clear as a bell. To be here today, as far as all this stuff came really quick to me, all these affairs happening. But it was clear from the very get-go that if we wanted to be here today, we would have to make our appeal before December 6th. We ended up getting around to making our appeal on December 10th, and that puts us into February 12th, I think, or February 8th, I'm not sure which. But the point is that I'm not hearing why we're here today rather than February 8th, when there's posted online rules that are clearly in the other direction. And so I'd love to hear from Mr. Lyons or whoever has the answer why we're here today, as opposed, why we're not here, why the rules were not adhered to. Thank you. Respectfully.
Are there any other representatives of the appellant that would like to speak?
No, thank you.
All right, would the city official please come to the podium, state your name, and offer your findings?
Good evening, Board. Danielle Sisman, Neighborhood and Development Services.
I can't
I'm buying myself a little space.
Excuse me, we can't really hear you
Yeah, I'm having
very
trouble
well.
hearing too.
Is there a volume?
How about now?
Because I can't hear.
Test, test, test. How's this? Better? Not better?
Not better.
Not better? I'll keep talking. Check one, check two. You guys can hear that?
I mean, I can hear you.
You can hear it?
But I have excellent hearing.
You don't count.
Yeah, I don't have excellent hearing, so I would appreciate it if you guys tell me when you can hear me or not hear me.
That's it?
We're maxed out. Okay, well, I'll speak as loud.
From the diaphragm,
Way you
perhaps.
can bend it forward.
Yeah, we're as good as we can get without it
Okay.
being overly familiar. So again, my name is Danielle Sisman. I'm the Development Services Coordinator in the Neighborhood and Development Services Department. The information that we were provided as part of this application is what's been worked up and included in the memos in your packet and the supplemental memos in your packet. A lot of what we're hearing tonight is new information to us, so we'll do our best to answer questions as you deem they're relevant to be answered. But my presentation tonight is primarily addressing what was presented in the application. So I'll kind of quickly walk you through this just so that it's into the record, and if there are any questions, we can answer them for you. But the staff memo, as I said, addressed the grounds of the appeal that's provided by the appellant, Mr. Moore, and his attorney, Mr. Gertis. The first ground for appeal that we're going to address are the minimum lot size, setback, building bulk, maximum lot coverage requirements as contained in Table 2A. So that's this table shown on the slide. It contains both minimum and maximum limits, and well, I'm just going to walk through each one of these one at a time, as I said. So the first thing is lot size, highlighted here. For this zone, which is RNS 12 zone, the minimum lot size and lot size per unit, in this case for one unit, because a single family would be 5,000 square feet. The site plan that was submitted with the building permit application, drawn up by an engineering firm, provides us a lot size of 2,842 square feet. This property, as a single-family use and in the RNS 12 zone, is eligible to make use of single-family density bonus options in the zoning code. Those would constrict the vehicular access to garages and off-street parking spaces, and then allow a reduction from 5,000 square feet to 3,000 square feet for lot size. I don't want to stop there, though, because actually this is a 319 North Van Buren is a non-conforming lot. So the provisions of Section 14.4E7C regulating non-conforming lots does apply to this lot. And that states that in any zone in which single-family uses are permitted, a single-family use with accessory structures may be established on any lot of record, notwithstanding, and that's just legalese for in spite of failure to meet the minimum lot area requirements of the zone. So the subject property is zoned to allow single-family uses. Therefore, in spite of the failure to meet the minimum lot area requirements of 14 of the table that it was shown here, the establishment of a single-family use on the lot is permitted. I'm going to move on to lot width. For lot width, the site plan again shows a lot frontage of 35.74 feet. This is a rectangular lot. You can see the dimension of the rear part of the lot as well, opposite the frontage. They're roughly the same. So we can infer from that with a rectangular shaped lot that it's at least equal to that dimension. We can measure it for scale as well. And again, per the footnote 8 in this table, for RNS 12, single-family density bonus options allow the minimum lot width to be reduced to 30 feet. So because it's measuring 35, it's well over that. The subject property is zoned to allow single-family uses and is, again, going to be restricted to vehicular access to the proposed dwelling from the alley, and therefore the applicable lot and width standards for the subject property of 30 feet is met. Moving on to frontage, as I mentioned, the site plan shows a frontage dimension of 35.74. Again, the RNS 12 zone and the Single-family density bonus options apply, and that means the minimum lot width can be reduced to 20 feet. So the subject property is zoned appropriately to make use of this density bonus. Is going to be restricted to alley access uses for vehicles, and therefore the applicable lot frontage standard for the subject property is 20 feet, and the standard is met, even without the density bonus of 25. Now we're going to talk about setbacks. The front setback for the principal building is what's itemized in this table. This lot does qualify for setback averaging, and because of that, the calculated average is 9.8 feet. The site plan, again, showing a setback of 10 feet, and so it is meeting the required setbacks. It's exceeding them, in fact. Moving on to side setbacks, again, this table shows this required side setback of 5 feet. The site plan shows the dimensions for the north and south side setbacks of 5.14 feet and 5.12 feet. Therefore, the minimum side setbacks for the proposed dwelling are met. For rear setbacks, again, there's a dimension of at least 20.55 feet shown on the site plan. We've also scale measured that drawing since it was provided to scale. It measures approximately 25 feet 9 inches. The subject property is located within the central planning district and has a lot depth of 80 feet, thus requiring a 20-foot rear setback. The site plan shows the rear setback, again, as I said, of 25 feet 9 inches. Therefore, the rear setback for the proposed dwelling is met. Building bulk is a maximum dimension requirement. This ordinance was recently amended. 27 feet is the new required maximum height. The site plan notes the building height of 24 feet 10 inches as measured from the average grade for this particular type of roof type. Therefore, the maximum height for the proposed dwelling is met. And finally, moving on to the maximum lot coverage. The site plan notes and calculates that using dimensions as provided by the engineering firm. It does meet that 40% maximum. It's a 39.3% coverage. Therefore, maximum lot coverage for the proposed building is met. Non-conforming rights were also included in the application, so we did address them as well. As I mentioned earlier in this presentation, we're talking about lot area. Our non-conforming section pertaining to lots, non-conforming lots specifically, does state that in any zone in which single-family uses are permitted, a single-family use and accessory structures may be established on any lot of record, notwithstanding failure to meet the minimum lot area requirement of the zone in which the lot is located. The subject property is zoned to allow single-family uses. Therefore, in spite of the failure to meet the minimum lot area, the establishment of a single-family use on this lot is permitted and not tied to the previous structure. And finally, the appellant has raised the issue of a conflict with a private sewer line and referenced 14.1b1b. To the best of staff's knowledge, there's been no legal proceeding to establish the establishment of rights for Mr. Moore claims. Regardless, it's not the role of the board to adjustment to settle civil disputes between parties, such as whether Mr. Moore possesses a legal easement over the Maher property. In any event, the decision to issue a building permit to the Mahers does nothing to offend Iowa City Code 14.1b1b. So the issuance of a building permit over a private sanitary service line easement is not a violation of the zoning code, and thus the Board of Adjustment does not have the jurisdiction over the easement issue. Appeals over the building code issues do go to a separate body. They go to the Board of Appeals, and Mr. Moore has filed a separate appeal to that board. That concludes my presentation on the items that were included in the application. And I think we've been keeping notes. I can try to address the other issues for you here quickly. If we need to dig into code references, though, I think it might take a few minutes, but we can try to do that tonight as well. Can I have my list? So, in regard to the window well, that is a projection. Staff would interpret those window well projections, since they are being provided as egress escape windows for basement habitation, as fire escape required by fire egress requirements, and the code does allow projections of those kinds of structures into the side yard setback. So even having just heard that for the first time tonight, staff would continue not to have an issue in interpreting that those window wells meet the code requirements for allowable side projections. In In regards to the handicap ramp, that's again a new issue, hearing it for the first time tonight. I might want to look at my code again. What comes to mind there for primarily is that there are processes to allow those kinds of structures to project or to encroach into setbacks, specifically handicap ramps. There's an administrative process where those can be granted. So a handicap ramp is not typically a large conflict. We tend to want to encourage ADA access. The city actually has adopted specific universal design and visitability standards under our building code to ensure that houses are built so that they can be accessible to all, depending on what you need in your life. So without digging into too much of the section provided tonight, again, that would not be a large conflict and probably would not impede eventual construction of a structure here through an administrative process. So if you would like me to address the question about when I think it was called a stop work order, but I think the actual words in our code are something slightly different than that. But if you'd like me to address the question of why work was allowed to continue up after a certain point once this proceeding started, I could pull that from the code. But there is wording in our code that says it's meant to stop work immediately unless it's unsafe to stop work immediately. So the determination was made that simply ceasing construction at the exact moment in time that we received the application would not be safe for the public. There were open holes in the ground that would have been dangerous, and that filling them in to a certain point made more sense and was better for the safety of the community than simply saying, stop here, of course. Now, the applicant was aware that they were doing that at their own risk. So they chose to proceed, and like I said, I can pull the words from the code if you need to hear them specifically, but they have to do with ensuring safety. So they were allowed to proceed up until a certain point at which we deemed it was safe to stop, and then they do need to stop. Is there anything I can answer or try to answer better for you?
So, yeah, so, okay, so Mr. Moore gave the staff his appeal on December 10th?
Yes.
Okay. So when did construction start on this project?
Construction could have started immediately after issuance of the building permit.
So when was the building permit issued?
Building permit was issued November 22nd.
November?
November 22nd. It's the beginning of your memo.
November 22nd, okay. So did they start, okay, so they can legally go ahead with construction at any point after November 27th, even if an appeal is filed?
So the appeal was not filed until December 10th. So between November 22nd and December 10th, there was no concern about an appeal.
I can't remember your first name.
Danielle.
Daniel.
Yeah.
So is the issue, one of the issues in front of us is whether or not we have jurisdiction over this issue of the easement. You've stated that we don't. We don't know otherwise. Is that a legal opinion, or is that staff's conclusion?
I would say that's a legal opinion, but I'll ask Eric Gores to join me here.
Eric Gore is the city attorney for the city of Iowa City.
I can't hear it.
Oh, I'll try. Sorry. Thank you, Danielle. It's on. Eric Gore is the city attorney for the city of Iowa City. Yes, the folks worked with the staff, consulted with our office to determine, whether or not this was an issue that's appropriate for this board as opposed to the Board of Appeals, which will be hearing this a week from tonight. And our conclusion was that no, that's a building code issue, not a zoning code issue. There is a forum for that appeal. It's been taken advantage of. They've availed themselves of that. That's next week. But insofar as the easement is concerned, in any event, there's been usually prescriptive easements. You need either something in writing to establish an easement or a judge's order, not just we claim it. Otherwise, people could be claiming easements all over the place and freeze up everyone else's construction. So our opinion was that that's a red herring insofar as this board is concerned. It's, maybe an issue for the Board of Appeals, but not for this board, in that until you receive evidence from the applicant that they have clearly established a prescriptive easement across the property of 319, it's a non-issue.
Okay.
And insofar as legal advice, that was our legal advice to staff, but you are being advised independently by Mr. Lintz, and so you should, of course, refer to or, think about what he says to you as well.
And I'm happy to weigh in on that if that's what, I try not to butt in unless I've asked a question.
So I do have a question, because the lawyer brought up on 14.1B, number E. Said when regulations are equally specific or when it is unclear which regulation to apply the more
Sure.
restrictive provision. So
There's a threshold question there is it unclear which regulations apply? Now, not certain that it is. But regardless, your jurisdiction, you are created by the zoning code. You live in the zoning code. Your jurisdiction is generally limited to violations of the zoning code. This is with respect to the other portions of this, say, in interpreting and applying the provisions of this title, right? This title is not intended to, with respect to item B, Mr. Gertis mentioned that or not to abrogate the rights of any other, the title is not intended to abrogate the rights or interfere with any easements, covenants, or other agreements between the parties. For example, let's say that North Liberty, the city of North Liberty, allows urban chickens. You're allowed to have urban chickens, but many of our neighborhoods have restrictive covenants, HOAs, that do not allow livestock to be held in your neighborhoods. We have a similar provision, and we interpret that provision here to mean just because we give you a permit for urban chickens doesn't mean that you're not bound by some other restriction. So just because we give you a permit for a building sewer, or for a building, doesn't mean that that interferes with anyone else's rights. So we're giving you permission to build a house. Well, if that building a house substantially interferes with someone else's easement rights, they have the issuance of a building permit does not delete their or infringe on their easement rights. But this is not the body to enforce easement rights. A property owner can go to civil. It's a civil matter for district court. You can get an injunction saying my rights are going to be violated by this and such. You guys are limited to respect with the setback and other provisions in the zoning code that you can fairly consider. So I don't know that I would call it a red herring. I just don't think it's applicable for you folks. If there is a conflict between the various provisions, for example, that Ms. Sitzman said, does this exception apply, or this other kind of exception apply? Does these various criteria that allow you to get bonus square feet or reduce the setback? I think that is what 14.1B1E is referring to. If you're not sure which one, follow the language in E. But I think with respect to the easements and other things, that is outside the scope of what this board does. Is that responsive to your question? Okay.
I'm not sure if this is protocol or not, but can I ask Mr. Gertis to respond to that?
Not yet.
Okay. I wanted.
We're still right now
I'm sorry.
at the
Yes.
city's presentation portion, and anyone else who wants to come up in opposition to the application after that, and then rebuttal and so on.
Okay. So Danielle, can you explain the density bonus?
Sure.
We read that a lot.
Sure. So RNS 12 is a single-family zoning district, so all of the primary dimensional standards and regulations that apply to it are coming from one specific chapter. In that specific chapter, there are the base requirements, which are this, it must be this, this, and this. But then there's an additional bonus that says, except if you're also these things, meaning if you have vehicular access limited to your alley, then you don't have to follow just the base standards. You can make use of the additional flexibility of the bonus. So in all those cases where the table I showed you says it had to be this, but I said, no, they can actually reduce that, it's because they're making use of the additional flexibility in our code specific to very specific situations. So if they meet those prerequisites of being in the right zoning district, the right kind of structure, and the right kind of access, then they can make use of those reduced dimensions.
Okay, thank you.
Danielle, do you feel comfortable addressing the question about the parking stall?
That is the one I did not dig the farthest into. I suspect, and maybe my attorney would tell me to stop talking now, but I suspect our code regulates required parking, and that area may simply be a non-required parking stall, in which case it wouldn't have as many restrictions on it. They have sufficient parking somewhere else. That's just a paved area, but that one I don't have all of the code references I could give you.
So what is the required parking for this specific structure?
I'm not sure I have that in front of me either. That's going to be coming from a couple different chapters. My understanding, though, is when we reviewed this permit, it met the required parking. It does meet the required parking.
It needs 3.
It depends on the occupancy, and I don't want to draw Parker into this because he would be my normal go-to guy to answer these questions. But if you need me to answer that, I'm going to sit back down and look at the book a little bit longer. But
Garage is a two-car garage.
It has a two-car garage, and so there's definitely parking in the garage. And I think that maybe this pad is the third place. I don't know for sure though. But parking has not been a concern for us in the review of this, obviously, and it was a new issue brought up tonight.
I mean, this alley is the only access this property has for parking, so they need some way to satisfy the parking off of the alley.
My point in rising is only to say that neither tonight nor leading up to tonight has there been any allegations that this property does not have enough parking.
Yeah.
I don't think that's for your consideration.
I have another question regarding, for instance, under minimum lot coverage, you meet the standard by 0.07%. Okay, now if we translate that into square feet, it's not very many. How certain are you of? I mean, was this property surveyed? Do we have? Are these estimates?
The drawings that were provided with the building permit were drawn up by an architect and an engineer.
I see.
So that's their liability to ensure they're doing that
Okay.
right. They rely on surveyors to draw those up. We trust that those third parties who are licensed in the state of Iowa are providing us accurate information.
In one of these clauses, you use the word approximately, and I'm thinking,
Yeah.
this boils down to square inches almost. I mean,
The approximately would probably have been us hedging on us measuring a scale drawing rather than sending it back to the engineer and saying, you measure this and tell us.
Yeah.
But in any case that we did an approximation, it was because we were already sure it was beyond the measure, but we were trying to give you as close as we could if it wasn't on that drawing already.
Any more questions?
Okay, so I do have a question then about the side setback requirement. You have said that the window wells on the north side, although they impede upon the side setback, are acceptable because they are for fire, egress in case of a fire.
Right, those are egress window wells so that you can get out of those rooms in case of a fire. I would interpret that, I'm fairly certain about this one, Eric, sorry, to be part of dimensional requirements for this zoning district, so 142A4, the allowed projections part, building features permitted within required setback areas. So 144A4, little letter C, fire escapes. I don't have the definition of fire escapes in front of me, but I feel like fire escapes can extend into any setback, not provided they do not extend more than 3 feet into any side setback. I feel like this is a fire escape apparatus for a subterranean unit, a basement window well.
Would you repeat that again?
Sure. I think that the described window well is most like a fire escape projection under the building features permitted within those required setback areas. And if that's the case, they may extend into any setback, provided they do not extend more than 3 feet into any side setback. So these window wells do not project more than 3 feet into the side
They're
setback.
2.5, aren't they? Then I do have a question about the extra parking space on the other side.
That I do not have an instant answer for.
Because it is taking advantage of part of the side setback.
It's probably, I'd have to look at the drawing again to answer that. If you want to give me a few minutes to do that, I'd be happy to do that, to see if I can answer that question. If that. Otherwise, that's certainly new information. If you want to, Madam Chair, if you want
to pursue
I would
looking
sort of
that
like,
up.
no, I mean, there has to be a certain amount of space for that parking stall. Right now, they're using part of the setback. If they cannot use part of the setback, then they have to move it farther north, and they could still have it.
I'd have to look at the drawing, but right, if there was some reason that they weren't in compliance with the code, they may very well have room to move it. I'd also have to look at open space requirements because they have to keep some of their rear yard open as open space. So there's a couple things in play, but if Madam Chair, if you'd like me to look at this, I can come back later in the proceedings when we have a rebuttal and provide it then.
Sure.
Okay.
That sounds good. Okay, at this time then, is there anyone else who would like to speak in opposition to this appeal, provide any information?
Good evening. Can you hear me okay? Thank you. I'll try to speak loud. My name is Matt Adam. I'm an attorney with Simmons, Perrine, Moyer, Bergman, and I represent the homeowners, Rob and Jamie Maher. I'm here to speak in opposition of this appeal. I first want to speak about this timing issue that seemed to pop up. I mean, I wrote down a lot of notes here, so I'm going to try to bounce back and forth, but my first thing I want to talk about is the timing of this appeal. This permit was issued on November 22nd, right? There is a deadline to file an appeal. Mr. Moore appealed this on December 12th, or excuse me, on December 10th. It's a critical date. I believe the deadline was 20 days, but someone could correct me if I'm wrong, which means it would have expired on December 12th, right? 20 days after the 22nd. He submitted his appeal on the 10th. He got a memo from staff stating that your appeal is inadequate. You have to list the grounds for your appeal, meaning why did you appeal? And they weren't going to consider the appeal until he did. You will see in your packet on, at the end of the pages, you'll see an email that was sent by Attorney Gerdes on the 13th, presumably supplementing his appeal and setting forth the grounds. I think that's critical because anything after that date, any grounds for appeal after that date cannot be heard by this board. It would have been untimely and an invalid appeal. That's our position. So we have to look at the 13th email to see what his grounds are. There was a lot of talk about side setbacks, window wells, ramps, a parking spot. None of that appears in your packet in that email. In fact, city staff was quite confused about these new grounds for appeal because they did not put any or address any of that in their staff report that they laid out for you. What they did address in their staff, but they've done a great job of kind of, going on the fly and addressing those issues. And I think what is clear is that even if those issues were in the appeal, it still would have been, the building permit still would have been issued. It's still valid. Window wells don't count. The parking space specifically is not required because there's 2 parking spots in their garage, and the ramp would have been granted as well. So my position is those issues should not be in consideration on this board because the appeal was untimely. Those issues were not raised in a timely manner. But even if they were raised, the application is still good. The building permit is still good. So when focusing on the zoning code, which is what this body is here to determine if the building official made any mistakes, I think staff went to great lengths in their packet to provide you a strong outline of exactly why this building official did their job correctly, right? And I would reiterate everything that Ms. Stitzman said in that regard. Is why the primary substantive reasons, forget the procedural stuff about timing, but that's also important, but substantively, this permit is still good. It meets all the zoning requirements. My clients worked diligently with city staff to make this project, to comply with the zoning code. They spent hours planning, designing, and working with staff to get this building permit, okay? So we would ask that you honor the permit and find that it is in fact in compliance with the zoning code. A couple of other things I want to talk about, even though I think the city attorney, Mr. Lentz, accurately stated it, there's been talk about this sewer issue, right? The board, they're correct, the board does not have jurisdiction over that particular issue. Mr. Gerdes and Mr. Moore are working under the assumed belief that an easement exists. It doesn't. I personally reviewed the abstract of title to this lot. It's a thick document. The abstract of title contains everything concerning real estate on this lot. There's no easement in here for a sewer. There's not. There's not one. So they are wrongly assuming and trying to conflict the issue by claiming they have a sewer easement. This is not a public line. This is a private line from one house that doesn't even abut this house across this lot. All right? It's a private line. In theory, we could cap it. We don't plan to do that. My clients tried working with Mr. Moore to figure this out once it became light to them. Once it became known to them this was an issue. Didn't get anywhere, right? They've been very accommodating. They've tried to work out, maybe we relocate it, whatever. But the real legal opinion in my mind is that it doesn't matter. You can build structures over sewer lines. There's nothing stopping that. Nothing at all. This is a hypothetical issue. They say, what if there's a problem? What if we have to fix our sewer? Well, that's a private matter between 2 property owners. It has nothing to do with this board. And incidentally, they've already put the foundation in the house. You know that because it was done before the stop work order was put in. It did not impact the sewer. He can still flush his toilet, run his drains, everything. There's no problem here. So I'm asking this board to put aside that red herring and not consider it. But even if I know you're humans and practically speaking, you should rest assured knowing this is a non-issue. Non-issue whatsoever. Let me see here. Going back to my timing argument, Mr. Gerdes provided a lot of information to you tonight, and I know some of you were concerned that you didn't have an opportunity to review it. I don't think, and in fact, it's my argument that that is a reason to defer these proceedings. Had Mr. Gerdes wanted you to have all this information, he could have presented it before the appeal deadline. He didn't. He chose not to. So we waived his rights. All of these things he could have provided in the time deadline to appeal. He didn't do it. So to now come with you and bombard you with this new information and ask for a delay, it's simply an attempt to further delay my client's project and cost them more money when they've complied with all the rules. And that's not something this board should support, and I'd ask you not to support that kind of behavior. He had his time to do it, and he missed it. You were provided a packet on Friday, the same as you would have been provided a packet before any other meeting, and time to digest it. And it had a lot of good information about all the reasons why you should deny this appeal. And we're asking that you do that. Those are all the comments I have tonight. If anyone has any questions for me or my client, I would be happy to entertain those at this time.
Anybody have any questions?
When did your client purchase this lot?
I can ask them, or I can look in this abstract. When? Looks like November 15th of 2024.
Thanks. Thank you.
Any other questions? Nancy?
I'd like to know about the wheelchair thing. I mean, we've talked about, you have talked about all the things that Mr. Gerdes has brought up, except for that. So I would like to know your thoughts on that, on the wheelchair ramp in the front of the house.
Certainly. I would have to defer to staff on that. Ms. Stitzman can hopefully, as she digs through the books, look to it. But I would use this as an opportunity to reiterate my earlier point, and that is that issue is untimely and should not be considered. If Mr. Gerdes would have raised it in a timely manner when he appealed, city staff would have that answer for you in their packet, just like they have all the other answers for this. I would argue that that should be a non-issue for this board, but I understand your desire to know it. I don't have the answer. The purpose, I would argue, the purpose of filing an appeal is to put everybody on notice of what you're claiming, to put city staff on notice, and to put my clients on notice so we can prepare for these hearings. We were not properly notified that they were challenging a ramp or a window well or an extra parking spot outside the building. We had no idea of any of those things. So it's a bit unfair for us to have to sit up here and defend positions that we were just found out about an hour ago. No different than city staff, and she's diligently trying to answer your questions because I'd want to know too if I were in your shoes, but procedurally it's not fair to me or my clients to have to address this stuff. Those issues are untimely. He didn't raise them. And so that's my only response, but again, I would certainly allow and want Danielle to answer that question, more so than she already has, which, as I understand her her position was that it would have been allowed had we known about it, because it's an ADA ramp.
I don't know if you can speak to this or Danielle might need to. Did the application for the permit include any modification request did that permit include any modification requests?
So a minor modification is a separate application, and no, we've not received
Okay.
a minor mod application for this property
Okay.
yet.
So this permit was granted without any changes to the zoning?
Correct.
It met all of...
The building permit was
Yeah.
issued prior to any minor
Okay.
modification request.
Thank you.
Is an appeal specific, or is it just sort of like a category? I mean, are they restricted to what they can present?
Yeah, if you're asking me,
Yes.
Mr. Russo, so we preserve items for appeal, and generally speaking, that this is not a court of law, this is a quasi-judicial entity, and so the rules for evidence and such are somewhat relaxed. Now, nevertheless, the arguments about traditional fairness apply, and the board is certainly allowed to disregard things that were submitted untimely, right? I'm going to stop short of encouraging you to do so. I would listen to the arguments from the parties with respect to whether you should or should not consider arguments that were submitted before the board, not included in your packet, in other words. The answer is generally, yeah. You're limited to the arguments you raise but in the appeal, the application, and you can flesh those out by the time the packet is due. The board does have some discretion. You know, it's easier if the parties were all agree, for example, and say, we all think we need more time to address these matters, then I might suggest the board consider doing that. But I don't believe anyone is, when one party's asked for more time, the city has not yet indicated whether they're interested in that, and the property owners are objecting. So I think that's within your discretion. I would, all things being equal, I would weigh the evidence that you have available to you if you feel you can make an appropriate decision based on the evidence you have.
Because when they under the city's synopsis alleging that minimum lot size, setback, building bulk, and maximum lot coverage requirements, you know, those are sort of categories. They aren't, I mean, when you say setback, that could include, wouldn't that include intrusions into the setback, the window wells, or a possible ramp, et cetera? I mean, how specific, you know, should he have said, well, this, and this, or, you know?
Oh, no, I think well, the concept is notice pleading, so you give the other party an idea of what it is you're going to be complaining about, specific, you know, and then that needs to be fleshed out generally with more detail before the night of the show, right? The nature of the problem is and giving the other party sufficient information to be able to respond is an essential element of due process and having fair proceedings. So I don't know if that's fully responsive to your answer. I can't give you my take on things. I can tell you what I think the law says, right? But there is, I'm not aware of case law that says you can't consider evidence that's presented right now, for example. But I would tell you that the principle is that generally you are allowed to disregard untimely evidence.
You're allowed what?
To disregard untimely evidence. You can. Should you, or must you? No, I don't believe you must. But I think when you make your findings tonight, whatever your findings are, you're going to want to be able to state effectively and clearly the reasons, all of the reasons for your decision.
So it becomes a question of fact then about appeal dates,
No,
filing dates?
I'm not advising you that the filing date has anything to do with this. The question is, before the board, in my estimation, does this building permit violate the zoning code. And the zoning code, specifically with respect to lot size, setback, building bulk, maximum lot coverage, leave off the part about the sewer line. Those are the questions that I think are properly before the board. Now, if you want to also consider, and without the city doesn't object to the additional details that are being offered in support of those tonight, sure. But other arguments about whether someone had a bad experience on another project, whether previous owners had difficulty with this property, the motivations of the city staff, unless absent evidence that not really relevant to what's here tonight. That what's here tonight is a ball or strike call. Was the city right or wrong in issuing the permit? And to do so, you're going to need to identify the specific code provision that they got wrong.
I would also like to state the burden of proof is on the appellant to show that they got it wrong. It's not on me or my client to prove that they got it right, although I think they did get it right. Right? I haven't heard any evidence to support that they got it wrong.
And Mr. Adam, I did mention that to the board earlier about the burden, so thank you.
Thank you.
Would anyone else who has facts or information in opposition like to come forward?
The pin is broken. Thank you. My name is Doug Fisher. I am a lifelong resident of Iowa City. I've been in the water and sewer business since '83. That's when I started my business. I'd like to, and I'm here just to talk about the sewer, not about the setbacks or any of that kind of stuff. I think there's a lot of questions that could be solved if this sewer was cambered and located long before any of it ever got this far as can you build over it, and all that stuff. That would answer a lot of questions about the integrity of the sewer. We know it's clay. It's probably 2-foot sections. Clay itself is a brilliant product for sewer. The downfall is there's a joint every 2 foot. Lets in roots. They shift, they let out water, and things get muddy and things start going wacko. And as I understand, I met with David Moore the day I dropped off my little excavator up there to start doing some exploratory digs to try to find the existing sewer to the house that they tore down to see if it was a viable sewer to hook this new house up to. It had nothing to do with his sewer, but he and I got into quite a little discussion when he learned that where the house was, and he mentioned, well, we talked about his sewer running over it, and we talked about, you know, yes, it's going to run over. I said, but if you don't know what it is, we should look at it with a camera. It's a $300 or $400 option, price tag, to look at it. I said, and if it's any question at all, before they start building, let's dig across. It's only, I don't know what it was, 30 foot across that lot, to replace it with PVC, put it in right with gravel bedding, and pack the ditch back up, and they can build a skyscraper over the top of it, because that sewer is going to last another 100 years if put in right. And what that also would have done is that sewer line would have been running still straight, assuming it runs straight, and everybody believes that it runs straight. But again, we don't know because nobody spent $300 or $400 to look at it and lay it out on the ground, locate it. If it does get replaced, if it in fact runs under that building and it doesn't, and it needs moved, let's say, then we start getting into a bunch of elbows and bends around to to divert out and around. Well, the city code only allows us 3 bends, a total of 135 degrees, before we have to put in cleanouts that come clear to the surface, and then they get in the way, they get broke, and it's just not a good deal. The ideal time would have been to do it before the construction started, put it in straight, and it would have been bulletproof for long past our lives. The other thing I want to say is, I was there when, after the foundation was dug, when the basement was put in and the garage footings were dug out. And I've been in business long enough to know that if at 100 years ago, if that sewer was put in there, you're going to see evidence of mixed up dirt between the clay and the dark soils when the ditch is back in. When it's wide open like that, and it was, you would see evidence of, yep, I could almost say right there is where that sewer line is because of the soils. I looked at it, I saw no evidence that there's a ditch running across in that spot through the garage areas where it is. Everybody's just assuming it runs through there. Nobody's cambered it, nobody's located it for $300 or $400. All this stuff about the sewer may be a moot point if it doesn't run under that garage. Yeah, shoot, I lost all this stuff here. It was mentioned earlier about who's responsible for the sewer. And Mr. Russo kind of hit on it. The homeowner is responsible up to and including the connection to the city services, which in this case is the main, which is in the center of the alley. And at no time does anybody else take responsibility for paying for anything. Even if they had a easement for that property, the homeowner is still responsible for the maintenance and the repair of anything that has to do with his sewer, no matter where it runs. As soon as it leaves his property and it goes on to somebody else's property and somebody else is responsible for the cost, most sewer repairs I do are either in the city right-of-way in the grass or it's in the street. Boy, if the homeowner could pass that cost back on to whoever property that is, they would love it. But I've been in business for a long time, and the homeowners always had to pay the cost, no matter where it is. Frank Wagner, oh, he's left here. He was talking about a job on Summit and Washington. I actually did that job for him 10, 12, 14 years ago. And he's right. He did move the sewer because the addition he was putting on that house, it did go over the existing sewer that was to that house. And what he's kind of forgetting is the new addition was lowered down lower, so the footings would have been into the sewer because there was a driveway elevation issue. In fact, if you drive by that now today, that house today, part of the driveway is still way too steep. It should have been lower. But we replaced the sewer. We went outside of the footprint because it was easy to do. And it allowed the house to stay running while we ran the new sewer in a whole new ditch. It didn't have to take them offline. But we put in the new sewer and new water service at the same time. So whether he had to do it because of the addition or in this case, it had to be done because the elevation was down into the sewer. There was no other way to do it. So that's just on that topic, just to kind of clarify what he was talking about. But I just want to bring back to the forefront. Nobody's located the sewer. Nobody's looked at it with a camera to see how bad it is. Oh, I did know that he has had problems with the sewer, as he told me. He said once or twice a year he has to have it cleaned out with a rooter thing because of roots. More evidence that it should be replaced, at least underneath that part of the property. I don't know if the problem is out that far, but, and it's
Okay.
deep, so.
All right, thank you.
Any questions?
Any questions? Okay.
Thank you.
Okay, can everybody hear me okay? My name is Jamie Maher. My husband Rob and I are the new owners of 319 North Van Buren Street. We bought this lot because honestly, we had this dream of being in downtown Iowa City. And we looked for a long time for different properties and different lots. And when we saw this lot, we looked at it and it was a unique lot, but I kept going back to it and loved the location of this lot. And I kept dragging my parents, my husband, everybody I knew back to this lot to show them, like, isn't this great? It's right downtown Iowa City. And I'm gonna here to tell you that we worked diligently for a long, long time. We knew the history of this lot. We were able to look it up. We knew that it had multiple appeals filed against it because it appeared to us that nobody wanted a house on this lot. But it's buildable. The city said it was buildable. It was sold as a buildable lot. So my husband and I, we worked diligently well before we purchased the lot. We went to the city. I actually met with Danielle at one point. We went through the code. I think I know more about the Iowa City Code than I ever wanted to know. I think I have nightmares about the city code when I sleep at night. Because every time we went through a code, I was just told, nope, that doesn't meet zoning requirements. And we'd try it again, and nope, that doesn't meet zoning requirements. Finally, after a couple of months of working on this, very diligently, spending hours, spending days, spending weekends. You can ask my kids, you can ask my husband, you can ask anybody that knows us. My husband and I, we put the time in to make sure that we meet every single zoning and building code to this lot. We put our hearts and souls into this. We did not want to do anything to hurt the Moore family. We approached them to discuss any concerns. We went and introduced ourselves to be neighborly. I even gave them a hug when I walked out of their house. And I made a comment that when we're all done with this, I could bring them cookies and we could be neighbors. I didn't think we'd be standing here arguing about this. We got our building permit and we went with it. We got the foundation in the ground. And I will say we worked on this a long time before we purchased the lot. So we had spent literally a couple of months working through the code and putting a house plan together. So even though we bought it on November 15th, we had been working on the plan well before that to make sure that it met zoning requirements. When they approved it on November 22nd, we were ready to go. We had our contractors ready to go because we were on a timeline for getting a foundation in the ground for winter. So we went with that. Mr. Moore told us that he would have to stop our project, and I questioned why. You know, we had done everything. We had met every single rule we needed to meet. We worked hard, and if there was something wrong, like, we were willing to try and help fix it. We didn't want to do anything wrong. The city didn't view us as having anything wrong, so we just continued to move forward. And I'm here to ask you today to, you know, you heard the city, you heard our attorney. I think the opposing side, I think their efforts tonight were kind of a last-ditch effort, and they kind of threw things at us that were like, here. But I'm telling you, we did everything we could to that code. And all we want to do is build a house. We just want to build a house in Iowa City. We want to get going on it. We want to get it done. We want to be proud of it. So I'm asking you tonight to, you know, rule in favor of that building permit. I think it will do nothing but help the city of Iowa City. It will do nothing but help that neighborhood. I mean, something needs to be built there. It's a vacant lot that was housing trucks and garbage, and we're planning to put up a beautiful home. And we did it the right way. I think the city was accurate in issuing us a building permit. And, you know, we just want to continue building. So that's all I have to say. Thank you.
Thank you.
Anybody else want to speak in opposition to the appeal? Is city staff ready with any new information regarding the window wells and the ramp and?
Sure. Let me offer what I have found for you. Regarding the location of the easement, I think we would like to point out, since our exhibit's been used a couple times, that letter that went out showing the line, showing the sewer line where it's approximately where it's guessed to be at. What I wanted to bring up about that map is that we've not cameraed and scoped that line, so we don't know that's the exact alignment, but we know that there are 2 points and they have to connect somewhere. So somewhere along the alley is a point where we know our manholes are and that there are connections to our service, and we know it's coming from the house. So that's the other point. So all we know is there are 2 points. We don't know if the line is a straight line. We don't know if the line zigzags. We don't know the line. That's unknown information. So I didn't want you to misinterpret that drawing in that letter that we sent out. I think you've heard a couple times. It's not established where the sewer easement actually runs. So just want to make sure you're understanding that map. The question about parking. So parking standards are set by zoning district and by use. So for this particular use, which is a single-family detached home in RNS 12, for a dwelling unit with 3 or more bedrooms, this is proposed to be a 3-bedroom home, 2 parking spaces are required, plus 1 additional parking space for each adult occupant beyond 3 occupants. So it really depends on the number of occupants in this dwelling, but the minimum requirement is 2, and they have 2 parking spaces in their garage. That section of our code is minimum parking requirements. It only requires a minimum amount of parking. If someone were to provide excess parking, these standards don't necessarily apply to that. We're just ensuring that there's a minimum amount of properly sized parking. So all they are required to provide for a 3-bedroom home is 2 parking spaces, plus 1 additional parking space for each adult occupant beyond 3. The exhibit provided tonight mentioned a 5-foot setback requirement. That's for principal structures. The 5-foot side yard setback is for your house. It's not for your parking stall. So whether it's in or not in that 5-yard setback doesn't really matter, and it may not even be a required parking stall. So you could look at it that as only it's just a paved area. Are they allowed to put a car on it? Only if it meets a certain dimension. It's 9 by 18, which is the required size for a parking stall.
If we look at the aerial of this alley, that's all. It's everything down that alley is just paved.
Right.
The entire alley. So that makes sense.
So staff does not see an issue with parking. Just review this tonight of our standards again. I think that's all I have for you from earlier. I do have the words for the stay of proceedings having to do with safety if you want those, but those are straight out of the section pertaining to your board activity.
Any more questions for Danelle?
I'm sorry, I didn't.
All right. So at this point, we'll ask for any final closing statements from the appellant or the appellant's representative.
Thank you, Greg Gertis again. Made a lot of different notes, so this is going to be somewhat rambling, so bear with me. And again, if you have any specific questions, let me know. Mr. Adam talked about the appeal deadline as being 20 days. That's incorrect. I would refer you to your own procedural rules, which you have adapted. They're on your website if you don't have them with you. The procedural rules say that the appeal must be filed within 30 days. The building permit was issued, as I recall, November 20. and the appeal was filed on December 10th, so well within the 30 days. It was immediately supplemented when city staff wanted more information. As city staff said, that email was sent on the 13th. So we still had a week to go before our deadline expired. Second of all, about the late submittal, again, it's kind of interesting that we received more information from the city this morning, and the city somehow is offended when we give them information today. That's kind of interesting. But again, your own procedural rules contemplate the way we handled this. Specifically, section 6, it says briefs. Brief is what I just gave you, a written discussion of the points. The board may request written briefs for legal argument. Applicants, that's us, may submit written briefs if they so choose. We did that. There's no deadline for filing that brief, okay? In fact, hearings are hearings. That's where we present our evidence. That is when we give you the specifics. And again, setback has always been an issue in this case, and it's unfortunate that our opponents want to hang this matter up on a procedural issue, even though we have met all deadlines by at least a week. Keep in mind that we hear our opponents. We're friendly opponents, but we're opponents, okay? Their interpretation of the code is not binding on them. My interpretation of the code is not binding on them or on you, okay? It's up to you to decide it because you get to be judges. Personally, I would require, if I was on council, that you all get black robes and maybe one of these wigs so that you look like a judge. You don't have that. But you're judges. It's up to you to read the code and decide what the code means, because that's what we're asking that you do. Again, the front setback issue is night and day. It's interesting that they say, well, if we had followed the process and gotten the minor review, we probably would have approved it. That process is exactly what happened the first time this matter was subject to a Board of Appeal several years ago, okay? Because what happened is that they went through that process and the Board of Adjustment said, hey, no, we're not going to let you do your minor adjustment in this case because your problem is self-inflicted. You're building too big of a property on that lot. And that's what's going on again here, too. Of course there should be a house built.
This permit had no adjustments on.
No, they didn't.
So it's not the same as the previous case you're referencing.
Exactly. They are subject to the code. Okay?
Correct, but you're citing a case that had an application for an adjustment. This one does not include that.
Correct.
Okay.
And what happened is the city, in that previous case, several years ago, the city went through that internal review process, and they approved the setback reduction, and the Board of Adjustment said no.
I'm familiar with it, but
Can't do that. So,
yeah. I know.
So, there is a process for them to go through, but that's not a surefire thing, and there are limitations, and there are rights, and there's a hearing procedure, so they haven't done that. Back to your question, Mr. Russo, about jurisdiction and the whole thing. The zoning code is not a smorgasbord where you can pick and choose what you want. The zoning code is the zoning code, and things are there for a purpose. And again, the authors of this zoning code put provisions in there as far as limitations on the rights of other parties is concerned. And in this particular case, you can see underneath the code language that private agreements are not meant to be interfered with by this zoning code. We've got this sewer line that runs across the property. We don't need an easement underneath the code. We just need an agreement. And we can argue till the cows come home about whether or not there is a legal prescriptive easement or not. Is there an agreement? Certainly there's been an agreement. That line has been there for 30 years, at least, because Moore has lived there 30 or 40 years. And the house is probably 100 years old at least. So that sewer line, obviously with the agreement of everybody involved, has been there. And now, when you compare the site plan with the size of the building, it has to cross that sewer line. The building is just too big, it extends too far to the west, and it crosses the line. And yes, we would like to do something about it. We've got a difference of opinion about the good faith efforts that have been made to try to rectify this situation. Mr. Moore is going to come up here and tell you about the cops being called on him and him getting served with a no trespass order when he was trying to have a discussion about this. And of course, nobody wants to stand the financial consequences of any of these things. The city says that the window wells that protrude on the north side are fire escapes. When I was reading the code, I saw that and I thought, what's a fire escape? It's not defined in the code. So I went down to the public library, as I am prone to do, and copied the definition of fire escape. And what Webster's Third New International Dictionary says is that a fire escape is a device for facilitating escape from a burning building as a stairway, usually of steel, attached to the outside of a building, or a wheeled extension ladder. I don't know about the wheeled extension ladder being a fire escape, but apparently it is to them. But this isn't, we know what fire escapes are. You go down to the Midwest One Bank building and you see a fire escape, and you can see them all over town. They are, just as what is said here, a steel stairway attached to the outside of a building. Now, that doesn't comply or comport with with a window well. Now, the city says that it was okay to frame out the basement and to put the floor joists in and lay down the subfloor because that's necessary for public safety. Around town, when I see this situation happen, what I see is some steel fence posts get driven in and around the site, and the old snow fence material gets put up, and that's where the building stops until the appeal is resolved. City talks about the parking issue. Again, that's something that you have to read the code for. And it says, off-street parking spaces are subject to the location and setback requirements specified in the base zone. We know that the side setback is 5 feet. And we know that this parking spot doesn't meet that 5-foot setback requirement. They're trying to say that they don't need it. If they don't need it, obviously they're limited on how many people can occupy that structure, how many adults can occupy that structure. And I submit that if they didn't need it, they wouldn't have shown it on the plan. But if it's shown on the plan, we should all expect that what's shown on the plan comply with zoning code. And as shown on the plan, it does not meet setback requirements. Same, of course, can be said of the front setback obligations. They've simply not been complied with. The ramp does not meet zoning code. That, they don't deny that, they just say, well, if we'd been pushed on it, or if we'd approve it. They can't just approve it. They've got obligations and requirements, so it's not a unilateral decision that they can make. And again, if it's shown on the plans, it needs to meet zoning code. And without even applying for a minor modification, it certainly does not do that. Again, the process we have followed is the process you've got in your procedural rules. We followed them specifically. We've met our obligations. We've given you clear-cut documentation of proof. And this isn't stuff that we're making up. This is stuff that comes from their plans. Okay? We're not pointing out anything that they don't admit. And as you can see in that letter, which is included in my brief, the current owners knew about the sewer problem since at least October 8th. It's unfortunate that they didn't make the effort to try to work out this situation rather than give the ultimatums and no compromises that they offered. Again, any questions? I'd be happy to answer them. Thank you.
All right, city staff.
Well, I'm Dave Moore again, and I don't know what exactly to say, except that, again, there's kind of been an implication that we're trying to rush things here with some paperwork that was passed out. But we got an email yesterday from Parker Walsh that it was okay to pass out paperwork. When you talk about rushed, this whole affair, I think part of it is that rules are rules, you know, and that these scheduling rules, where our meeting should have been in February, are just rules. When you look at the amount of days between December 20th and today, that's like, what, 18 days? And if you take out all the weekends, and if you take out Christmas and Christmas Eve and New Year's Day, you end up with about 10 to 14 days. You know, it's not. If there's any rush here, we feel rushed. I know that. As far as us waiting, December 10th was the day, in part because excavation, for me, it was like, whoa, they actually are doing this, okay? And then we get together and we file, and we know that date is a date that puts us into February, and we hope we have some time. Okay, so that's that stuff. As far as the stop work order goes, I've got photos that are dated. That orange sign that says the stop work order, it begins December 18th. Okay, so on December 19th, they did not just put some sheathing on top of the foundation. On December 19th, they framed in the rooms in the basement. They actually framed in the rooms in the basement. That has nothing to do with public safety. it was one day after the stop work order. I have a photo of rooms that were framed the day before, the 18th, rooms that were not framed. So that was just plain violated. I think when Mr. Fisher and I had a really amiable conversation, and the way I remembered is that this whole thing is coming fast, and that I think I told him about the events in our lives that were really crazy in the next 4 or 5 days. But the date when Mr. Fisher and I talked was the 26th. Excavation started around the 4th or 5th, and then the final thing is that I think it's the final. I'm going to check to make sure, you guys, because I can barely read my own handwriting. And that's just, I think that's pretty much it. Except that from everything I've heard, from a common sense point of view, every contractor I've talked to, every realtor I've talked to, their first reaction is, you got to be kidding me. That sewer's been there for 100 years. You got something called a prescriptive easement. This is like, they can't believe a permit was extended over that sewer line. That's just a kind of a common sense thing that I heard of, about this prescriptive easement. I think the last thing, and I've kind of rambled a bit, and I apologize for it. You guys we've been here a long time. I hope you take as much time as you need to look at these other code violations. It's back to the same thing, just rules. But the one thing I mostly wanted to respond to is what Mrs. Mayer said, that she tried to work with us. Mrs. Mayer and her I believe father-in-law, Mike Krantz, were in our home on the day of December 5th, and it was their stance was very clear, and my wife's here, she could back me up if she needed. It was very, very clear, is that we're sort of like, it was simple, and I wrote it down. We have two options. They gave us two options. That's it. We build over it, which they'd already done with that foundation. We build over your sewer line, or move it at my expense. And so that's a whole different deal than what she's implying. So that's my interpretation of it. That was, my wife asked that question directly twice. Well, you mean you guys pay for it? And they said, no, it's your sewer. You pay for it. And that's not understanding of what it is. So we were firmly told that we only had two options. We build over you guys, or you pay to move it. That's pretty much it. So that's all I have to say, and I hope you take as much time as necessary to consider these things. Thank you very much.
Okay, city closing remarks.
Eric Goris again. I'll be brief. You folks have been hearing about this already for some time. It is the city's position that the board should be making their decision tonight based on matters raised on appeal within the 30-day appeal deadline. Tonight, of course, is well past that deadline. I assume that when Mr. Moore chose to file his appeal, he knew why he wanted to file his appeal. Otherwise, that appeal would have been in bad faith. And if he knew back then why he wanted to raise his appeal, there's no reason why he couldn't have specifically delineated all the things that he provided to you tonight. He didn't. I think there's probably a reason why he didn't. But in any event, like Mr. Adams said, I agree 100%. You should only be basing your decision based on matters that were raised on appeal timely. Of those issues that were properly raised and timely raised on appeal, Ms. Sitzman made clear why nothing about the issuance of this building permit offended the zoning code, even addressing some of the matters that she was hearing about for the very first time tonight. The sewer line is at best, from the appellant's perspective, at best an issue for the Board of Appeals, a building code issue for the Board of Appeals to consider. The reality is it's a civil matter. It's a private matter between the Mahers and the Moores. It's the Maher's property rights versus Mr. Moore's claims of property rights, and that's not for this board to decide. That's a private civil matter. You may have noted that Mr. Adam indicated he had searched the abstract looking for evidence of an easement and found none. That went uncontradicted. Finally, appellants have not met their burden of proof, and I want to reiterate, it is their burden of proof to indicate that the building permit was improperly issued, and for that reason, we ask that the Board of Adjustment, affirm the housing official decision. Thank you.
Okay, thank you. Any final questions from the board? Okay. At this time, I will close the public hearing. Can I have a motion, please? So in this case, the motion needs to be either to affirm the decision made by the building official or to reverse the decision made by the building official. Is that correct?
Yes, Madam Chair, those would be the options. I would remind the board that there is no requirement to affirm the city's decision. The city's decision is going to stand unless reversed. It may be easiest to have a motion to reverse the building official's decision, but that would need 3 yes votes to pass. That would, conversely, a motion to affirm the issuance of the building official's decision would still need 3 votes to pass, but that would resolve the matter the other way. So, am I being clear as far as what's required? I know it's clear as mud. You have your board rules, Section 11, say your motions have to be made in the affirmative, approving the requested action. Okay. You could improve the traditional way to interpret that is, I move that we do a thing rather than I move that we not do a thing. Doing the thing could be affirming or reversing, but I think for the sake of clarity, I think a move to reverse, then seconded, and with following discussion and amongst the board, it would need to have a roll call vote at the end of it. But you're not there yet. I think you need to have some findings of fact. Okay. I think you need to have some a robust discussion amongst yourselves a little bit and figure out what you think and why you think it. Then I would recommend that you make a motion to establish what your findings are that you agree on. At that point, then I would suggest that you make a motion to reverse, and then that motion would need 3 to pass. If it doesn't, if it's 2-2 or 4-0 or whatever, then it's resolved the other way, and that would be a final resolution of the matter as well. Does council agree with me on the
yes.
Burden and the appropriate resolution here?
I do. The only other thing that I would throw out on the floor is that the council, if the board, if it wanted to, could defer.
Yes. the option to continue these proceedings, I would urge you not to. Just unless you find a compelling need to do so. But you do have the ability to table this for another day. I would recommend, people are spending money on attorneys to be here tonight. People have set aside their schedules. This is a big deal for the parties. And so I would suggest that the board honor their appointment and stay here and do the work necessary to resolve the matter to the best of its ability. If you cannot, then you'd want to consider moving to a different direction. But those are my thoughts for the council, or for the board.
Okay, so shall we have a discussion then? Some findings of facts? Anybody?
So you need a motion.
He's saying we don't need a motion yet, that we can
Have a discussion.
we have a discussion and then,
The discussion will lead us to a motion.
Yeah, Section 10 under board deliberation says, after all the parties have been heard, the public hearing will be declared closed so that the board may deliberate the case. You may deliberate amongst yourselves. I would encourage orderly discussion. I recognize your fellow board members to say, I think this or I don't think that. Come up with some consensus so you have so that when we're taking minutes and entering the final facts of the case, it's easy to understand what the reasoning was for whatever your ultimate decision will be.
I can give it a shot. You want me to start?
yes, please.
Okay. So I've been on this board off and on for several years, and I mean, the charge of this board is to deal with zoning questions about individual properties. So the easement thing to me is a non-issue, and I think the appealing party agrees with us. They've already put this before the Board of Appeals, so I think they acknowledge the easement is not our issue. It's the individual lot, and whether or not the permit that was approved meets the lot requirements. This is a non-conforming lot. This is an old lot. This neighborhood is old. We have the non-conforming adjustments for this very case, where we have someone that wants to build a new modern building on a funky lot in a funky part of town. All I need to do is go to page 2 of our packet, code 14-2A-4. There's the table that we've referenced before, and we're comparing the numbers there to the numbers on the permit. There's not one number in their permit request that exceeds that table with the non-conforming adjustments that are available for this lot. But I want to hear more. That's where I'm sitting right now.
For the ease of discussion, members of the board, you can choose to, for example, adopt the statement of another member or adopt minus a certain thing or expound on it. But we'll want to continue an orderly discussion if you can. I have total faith in your ability to do so.
As far as the lot size, the setbacks and everything, the general measurements on everything are as is stated in the zoning code. My concern is with the 2 window wells. Those are 2 of the things, and in here it says balconies and bay windows may not extend into the required side setback. So this is a sticky point, but it's okay. If we say that this is okay here, then are we opening the door for other instances?
No, the decisions of this board have no precedential value whatsoever. You are ruling on the specific question of whether this building official made any error in issuing this building permit for this lot. If you do find, you're going to have to specify what the error was, right?
I would just point out, I mean, a bay window or a balcony is very different than an easement window out of a subterranean floor. And, I mean, I think if you look around town, you'll see that this has become a pretty common way for people to maximize the square footage on some of these lots, is to have livable space, subterranean with the easement windows that are in this design. But they don't have the same impact on the setback that a balcony or a bay window
No.
would have.
No, I agree with that. It's just,
I
you know,
understand you. I
that
understand.
is one of the.
It's also not a, you could argue that a window well is not an architectural feature, but rather a feature of landscaping.
Sure.
And in other words, you could grade, that could be graded in such a way that wouldn't violate any of the setback requirements and still allow for egress. So I don't know. I think that there's a little confusion about that in my mind about, you know, whether it is architectural or whether it is, you know, a question of sort of landscaping and grade. So.
Well, I would say that I don't consider the window wells the same as bay windows. They are definitely a different feature. I'd also say that I agree that the sewer line is not anything that we need to consider.
No. I don't think that's in our purview. I don't want to deal with that. I think we're here to deal with the zoning code. That is the major thing. The dates that things were introduced, the dates that they were supposed to be introduced and all that, that's getting into the weeds. And we could spend a lot of time on that, but that, I think the major problem we need to deal with is the zoning code. Or at least that's how I feel.
No, I agree.
This is a pretty tough one. This is sort of why I want to leave the board. It's unfortunate that it arrived at this state. You know, I'll just say that. It's unfortunate that for one reason or another, this occurred this way. You know, you would think that we're all intelligent people, that we could prevent something like this, but apparently not. Honestly, I think that the city's done its due diligence. I don't think this board should get involved in issues of questions of whether or not there's an easement. Those issues will take us, it'll turn this board into something else. I think there are questions about you know, I personally would have questions about the building, you know, the building size and the arrangements, et cetera. But I think that they've crossed their T's and dotted their I's. I think that they've conformed to the tables and the size requirements pretty diligently. I just don't see a strong basis to overturn the city's building permit at this stage.
I would agree with that.
The appeal request was to overturn the decision. I'd like to make a motion that we let the decision of the building official stand for this permit based on the factual knowledge that we've reviewed, that all of the permit specifications met the code that applied to them.
I think that's a sufficient motion. Is it seconded?
We have a second? Seconded.
Okay, now you get to talk even more if you want.
I think all of us would like to see a cute little cottage on a little lot. You know, I think that's the dream of all of us. But that is not the reality. And we need to deal with the reality of what can be put on there, and can it contribute to the feel of the neighborhood. So I think we need to look at reality and live with our little dream off on the side.
Yeah, no matter what any of us would prefer to see, we have to just abide by the code.
Well, I mean, I think this is what I mean, I've been in Iowa City for 25 years, and part of why I do this board is because I'm invested in this city. And I think I think the code and our ongoing evolution of the code is trying to do what you're describing while encouraging people to keep investing in this town and having housing that makes sense for them. And this is a case, this is exactly why we have some of the pieces of these ordinances and the non-conforming component, so we can have families invest in a modern home on a lot that really wasn't, it wasn't the original idea. It was I mean, I remember the original building. That's not our current state, and it shouldn't have to be. So I mean, I feel like this permit was following the entire intent and the guidelines in our ordinance, and fulfilling, encouraging investment in our inside the city, and infill, which we also want to encourage ongoing investment within the existing city. So those are reasons outside of the code that it's encouraging to me that this permit met them.
Madam Chair, when you feel like discussion is ended, you can ask Mr. Walsh to poll the board for votes.
Any other comments? Okay, well, let's have a roll call vote then. And would you remind me of the motion?
The motion before the board is to affirm the decision of the building official to issue a building permit. An aye vote will overrule will terminate the appeal and allow the building of the house to continue. Absent some other legal proceeding in some other venue, which is not for you to worry about.
Okay.
Carlson.
Yes.
Cox.
Aye.
Russo.
Aye.
Swigert.
Aye. Oh, I got to read this thing here. Wait a minute. The motion is declared approved. Any person desiring to appeal this decision to a court of record may do so within 30 days after this decision is filed with the city clerk's office. Thank you. Somebody want to get Larry?
Madam Chair and friends, thanks for letting me help you out tonight.
Thank you.
Thank you for your help.
How much
your
more is
help.
there?
A few more items left. I
Larry's,
think these ones will be quick.
make sure he's awake in there.
I think these ones will be quick. I said a few more items left.
2 more items.
Okay.
Make sure she's
One is an election.
Maybe
Do you
15
need me to stay part of the agenda if Larry's coming? Because I think I was.
Yeah.
I would switch.
Okay.
Yeah, I would switch.
And it's just kind of.
All depends how much you guys want to talk about before.
Automatically, but knowing that the body was here just kind of ruins the whole thing. I'm not going to need any of these materials. May I leave them here? Thank you very much.
He's got to build something.
Okay.
All right.
Thank you so much for coming tonight.
Thank you.
Ernie, thank you so.
Thank you, Grant.
Thank you.
Take it, Greg.
before starting over again?
The other items are.
Yeah, it shouldn't take more than 15, 20 minutes for that.
No, and Mark wants to hurry up. How about yourself? His wife is ill.
Oh, okay, we'll get it.
You should, you know, every year there's an opening. 'Cause there's 5 people, and there's a
Yeah,
5-year term.
there's an opening now. isn't
Oh,
there?
just
Half
got
the people
appointed.
leaving pissed and half the people
Person
happy.
right there,
I
George
know.
Froman.
Oh, is she?
Yeah,
Like
Okay.
sitting there
got appointed last
saying,
night.
Okay.
Yep, bye-bye,
Which
Ernie.
all decide?
We
What our meetings could be like.
supported the
Thank you.
decision made by the building official.
Thank you, Ernie.
This is the exception rather than the
It is.
rule.
How come he's not back on here? It should be on here.
At this point, I turn the meeting back over to the chair.
Thank you. Did I miss anything while I was gone?
No, nothing of consequence.
Did you stay
No, we
awake?
sat here and twiddled our tail. Well,
I took my
There may be a-
crossword puzzle.
There may be a brick in your window. Other than that, nothing.
Okay, the next item on the agenda is discussion of a report from the city attorney regarding the, how to apply the definition of substantial or diminished property as a statement of fact. So, you just want to open questions? You want to summarize? How do you
Well,
want
however, I know it's the board's been here a long time, but this was a request of the chair to expand on that criterion, which is not necessarily specific, but I think what's important for the board, as I concluded, is that, as what the Supreme Court said when it looked at this, it said that expert testimony is not necessary. So if you're looking at whether it impacts or diminishes the value, you do not have to hear from a real estate broker or an appraiser. That's not required to make a decision. Also, anecdotal, personal experience is important. And also your common sense, inferences from what you hear is important. So all of that should be taken into consideration. And the other thing I want to point out, it's just not the diminishment or the impairment of property values, but the substantial diminishment or the impairment of property values. So that's very important. And again, it's the burden of the person making the application for this special exception. So those are the things I wanted to call into question. Yes, or call into mind.
It's a substantially
Substantially diminish or impair.
Okay, does that have to be all the properties or one property or?
It's the values in the neighborhood, so more than one, obvious one. And the neighborhood usually means, more than one, right? That's what we look at. I'm reminded of one time we had, as we often do, barking dogs. There's a neighbor who complains about a barking dog. And it's just usually one neighbor because there's usually neighborhood issues, right? And the judge said, well, the code says it has to be a disturbance of the neighborhood. One person isn't a neighborhood. So I think that's what it means. It's to more than one property, yes.
Questions?
Okay. And I thought you might find it interesting that it was the shelter house case.
Yeah.
You should kind of maybe remember it a few years ago when well, they've been now there probably 10, when was this decided? In 2008. Yeah, so they've been at that, haven't been on North Gilbert for nearly 20 years now.
I thought it was interesting that it was a case from Iowa City.
Yeah.
Not another city. It was
Right.
from something that had
Right.
happened, that when happened
Yeah,
here.
right.
Well, thank you for that.
Yes.
Nancy, you have any other questions? I got a couple.
Sure.
I just want to understand this process. The burden of establishing whether the project creates a substantial burden starts with the applicant. He or she determines that?
Will not. That's kind of in the negative, which is, so what you have to find is that it will not substantially diminish or impair property values. So that's what the applicant has to prove, is that it will not substantially diminish or impair.
I don't have any old
Yeah.
prior staff reports, did not have any
Yeah.
prior staff reports in front of me, so I couldn't go back and review the language that's used. But the applicant has to establish it will not. Does the staff have the chance to agree or disagree with
Yes,
that?
yes, just with like all the criteria, yes.
Okay. So the staff can overrule the applicant?
Sure, and that's the report you would get then. You would
Okay.
hear from staff, and then the applicant would come to the podium and say, well, we disagree with staff, yes.
Okay. And the applicant does not have to provide proof, he just makes the assertion?
Well, there has to be something there, right? It can be anecdotal. It can be just other people who have said, hey, anecdotally, like they did in this case, well, we lived by this same situation in our neighborhood, and it didn't affect our things. Or the applicant can come in and say, hey, I've got this study, and here's some studies in Des Moines and in Cedar Rapids and in Burlington where all this similar thing happened and there was no impact on values. So you could have something like that.
Okay. This question for me came out of an issue, God, it's been like 2 or 3 months ago.
Right.
And I remember at that time, there were over 100 signatures on either letters or petitions.
Right.
And I went through and made a list, and all 100 of them signed on to this issue as at least one of their issues. And so we're saying that it's their obligation to disprove the applicant and the staff, to say that it will create a substantial.
They have to convince you of that, yes.
Okay. And you said that just one complaint doesn't really justify a decision one way or the other.
No, I think the question that Nancy brought up, does it impair one property value or more? And the provision talks about impair property values in the neighborhood. And that, to me, would be more than one property.
Okay. Is there a difference between the value of the anecdotal evidence assertion made by the applicant versus the anecdotal evidence or assertion made by the objectors?
You have to weigh that.
Okay.
And again, you know, there's the burden. So,
as I recall, one of the objections cited the withdrawal of a sale of property. That wouldn't establish a neighborhood problem. It would only establish that for that one property?
right, because the criteria is it will not substantially diminish or impair property values in the neighborhood.
Okay.
So, I mean, you could look at that and say, well, that's one house. Can you then reasonably infer that would impact other properties? Because you can have common sense inferences drawn from the evidence. So if you're applying your common sense and you say, gosh, yeah, that did impact it, but, you know, that was a corner lot. It was, you know, 7 or 8 houses away. It was an old house that, you know, probably needed to be rehabbed anyway, whatever. Or it was a brand-new house, and goodness gracious, the property value went down by 25%. Well, you might have different inferences drawn from that.
Well, no, in that particular case, the property devaluation was supposedly based on the original application and the original location chosen by the applicant.
Yeah.
But that property, eventually, by the time it got to us, had sold for $1 million. So I know that, so that's anecdotal evidence on my part.
Exactly.
Could I have introduced that as?
Yes, yes,
okay.
yes.
Is the anecdotal evidence, does it have to be presented formally at a meeting or someone's letter?
It can be someone's letter.
They just send a letter, so there's
Yes.
no way to question or.
Right, and so then you probably give it less weight because you're not able to ask them questions. It's still evidence, but it probably is less
Yeah, the
less
thing I was
weighty.
hoping for in this whole process was a little less subjectivity.
Right.
And a little bit more clear standards that we could go by.
Right.
But when we go back on anecdotal evidence being acceptable and to be evaluated subjectively, weighed by common sense.
That's why we have a 5-person board.
Yeah, that's why we're so,
So in a case, in this type of case, let us say you have one new construction or whatever, and it takes 10 years, but it eventually, it slowly impacts the whole neighborhood. Because oftentimes, one change doesn't appear to have any influence on the neighborhood, but it does. So can you use that type of example and say, okay, at the moment that it was done, the neighborhood stayed the same, but then over years, it changed the makeup of that neighborhood?
Sure, and then you just have to decide how much weight to give that.
have you had any experience where, I don't know if this is a fair question to ask, that the subjectivity of the board, in your view, was not coherent?
No, I think you get, 5 reasonable persons who try very hard to listen and to come to a reasonable decision based on their life's experiences and what was given to them. Right?
Okay.
No.
All right, well, I appreciate it very much. Any other questions? Next order of business is the election of officers.
So we need to elect a chairman.
Yeah. we
Start with
just-
the chair and then the vice
yeah,
chair.
Nominations for the office of chair, right.
I would be glad to serve again, but if someone else would like,
Nancy, would
Has
you
strong
like the
feelings.
opportunity? It's your last year.
I did it once. I gave my time for 1 year.
Just checking, 'cause it's your last chance.
It's my last chance, that's all right. That's fine.
Okay, well, I nominate Larry to serve as chair.
I second.
I was timing that. All right, thank you. Any other nominations? If not, we'll call for a roll call, or is it a voice vote?
Carlson,
Yes?
Baker,
Yes.
Russo.
Yeah.
Swigert.
Yes.
So then we need a vice chair.
We need a vice chair, open for nominations.
I'll take that if you want.
Oh, that would be great. Mark volunteers. I nominate Mark. Do I have a second? He's thinking about
I'm
it.
thinking
but
about
he's
it.
gonna
I'll second that.
You don't have to.
Any other nominations?
No,
No.
I served
All
twice.
those in favor? Or, I'm sorry, roll call?
Baker,
Yes,
Carlson,
Yes?
Russo.
Okay.
Swigert.
Yes,
good.
all right.
Next up is the consideration of minutes for November the 13th. Any changes, recommendations?
What was the last one?
The minutes,
Oh, okay.
I had no changes, no. Okay, so I move to approve the minutes of November 13th, 2024.
I second.
Moved and seconded. All those in favor?
Aye.
Any other business, which can't be on the agenda anyway?
Well, real briefly, this is your new member. Julie Tallman was appointed by City Council last night as the new member of the Board of Adjustment.
Hey,
I have-
all right, welcome.
Julie Tallman?
Julie, how many years did you work for the city?
28.
28.
Great.
Very good. Thank you very much, Julie, for applying.
She will bring facts.
All
this
right.
Thank you and welcome.
Did you have fun tonight?
It was interesting. I mean, I pulled up, I brought my big
Maybe we ought to adjourn.
All right, we have adjourned the meeting, right?
Oh,
We have adjourned the meeting, okay.
have we?
We're out of here.
I thought did we have the vote?
Yes, you voted.
All right, not that I got a memory problem. All right, thank you all.
Thank you. Thank you.